What happens if a jury finds that your doctor was careless, but that his carelessness was not a cause of your injuries? Can you still get money as compensation? Can you still get a jury to give you money? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, you get nothing. If the jury determines that your doctor was in fact careless and violated the basic standards of medical care, but they find that his carelessness, those violations, the departures from the standard of care, did not cause or contribute to your injuries, guess what? That's the end of your case. Finished. Done. You get zero. The jury never even gets to the next series of questions, which talks about how much money you are to receive. You have to understand, at the end of a trial, the jury verdict is made up of a series of questions that they have to answer. It's known as the jury sheet or the jury interrogatories. Now, an interrogatory is simply a question and an answer. So, when the judge tells the jury they have to go back and start deliberating to decide whether you are entitled to a verdict in your favor, it's not simply a one-question verdict. Hey, are you entitled to money? Yes or no? That's not how it works. That's not how any of it works. So how does it work? The way it works is this. The judge will give the jury a series of questions to answer, and they have to be done in sequence. The very first question that the jury will have to answer is, in this medical malpractice case, is, was your doctor negligent? What does that mean? It means, was he careless? Did he violate the basic standards of medical care? And there will be significant testimony during the course of trial to establish whether or not this doctor, the doctor whom you have sued, did in fact violate the standard of care. Obviously, your attorney is going to have various medical experts to support your claim that your doctor was careless. The doctor, on the other hand, will have his attorney and his medical expert come into court to say just the opposite, that everything he did was appropriate and he did not violate the standard of care. And then the jury has to decide who they believe. So that's the very first question the jury has to answer. Was the doctor whom you have sued careless? Was he negligent? And if the jury answers no, that's it. That's the end of your case. And you get zero. If, however, the jury says, you know what? Yes, the doctor was careless. And now they have to go on to the second question. And what is typically the second question? Was the doctor's carelessness a cause of your injury? You see, there has to be that connection, that link, that bridge between the carelessness and your injury. We call that proximate cause. The law calls it proximate cause. But for our purposes, there has to be that connection. There has to be a link. If, for whatever reason, there is no connection, and now the wrongdoing did not cause or was not a cause, it doesn't have to be the cause, was not a cause of your injury, guess what? The jury is told to stop right there. Don't go any further. And that's the end of your case. The jury never even gets to consider how much money you are to receive for the pain and the suffering that you endured from the time of the wrongdoing up until the time of trial. They never get to evaluate your pain and suffering from the time of your trial into the foreseeable future. They will never get to evaluate your lost earnings. The jury will never get to evaluate your economic losses, your financial losses that you're able to document. Nor will they ever get to any non-economic damages such as pain and suffering. The jury never even considers that if they determine that no, there was no connection between the wrongdoing and the injury. Now you might be thinking, how is that possible? You've spent all this time and effort and energy, and your attorney has done the same thing, and he's gathered various medical experts to go ahead and support your particular claim. The reality is that in a medical malpractice trial, in any type of trial, especially civil trials, nobody knows what the jury is going to do. The jury, 6 members of the community, try to come together to reach a consensus about the evidence and the testimony that they've heard during the course of your trial. Now, you should know, and I don't know if you're aware of this, you don't need all 6 members of the jury to reach a unanimous decision for each and every question that they are asked. Instead, they only have to be 5 out of the 6 jurors that have to agree. So, let's get back to the original question I raised in the title of this video. If the jury determines that your doctor was in fact careless, that he was negligent, but his carelessness was not a cause of your injury, can you still get money? The answer is no, you can't, because your case is finished. It's done. It's over. And once the jury comes back with their verdict, the next conversation you're going to have with your attorney is whether or not you're going to appeal this jury verdict. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in these medical malpractice civil trials here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.